There was a sad case there reported in the media of a woman in the High Court losing an application to appeal a home possession order against her. What's particularly galling about this case is that the lady in question paid €14,000 to a non-lawyer for services that he was supposed to provide to her, but he misrepresented the situation and an order for possession has been made against her. She's losing her home to Start Mortgages, and the judge is saying that it's beyond concerning that people with no legal qualifications are indicating they can assist people for fees, those in mortgage arrears. She's a mother of two. She has been refused more time to appeal an order for possession of her County Kildare home. She relied on misrepresentations by a man with no legal qualifications about how to deal with the possession proceedings against her by Start Mortgages. She paid the man €14,000. The judge is very concerned that Agnes Ryan, the lady in question, chose to take this man's advice. Start Mortgages sought the possession order over arrears of €500,000 loan made in 2005 to Miss Ryan and her husband. Start acquired the loan in 2015 and they made an application for possession of the property. They started possession proceedings in 2016, and Miss Ryan said in an affidavit that a man identified to her as knowing something about mortgage arrears. He told her that not to make mortgage repayments after 2017, that he was liaising with a representative of Start on a settlement and would take on Start and prevent a possession order being issued. Start's civil bill for possession came before the Kildare County Registrar in September 2021. It was adjourned to February 2022 on condition that Miss Ryan appeared in person and or who appeared in person, that she pay €1,500 mortgage repayments monthly from September 2021. In February 2022, there was no appearance in court by Miss Ryan, and an order for possession of her home in Suncroft, County Kildare was made with an 8-month stay on execution of that to become permanent if €2,850 was paid monthly. She said that the man told her that she need not attend the court in February 2022, that a representative of Start had agreed to adjourn the case and counsel would take care of the matter. When the possession order was made in her absence, the man told her he would file an appeal to the High Court, but solicitors engaged by her in April 2022 had established that he had not done so. So no appearance or no appeal was made by the man. An appearance on behalf of Miss Ryan was entered in late June 2022, and her solicitors then issued a motion seeking an extension of time to appeal the order. When that was refused by the Circuit Court, she appealed to the High Court, and the judge in this case, Mr. Justice Heslin, concluded that Miss Ryan was not entitled to an extension of time to appeal and had not made out statable grounds of appeal. He had a great degree of sympathy for her. He said there must be personal sympathy for someone who decided for whatever reason to retain and pay a person despite knowing that they were not a qualified lawyer, but he had to emphasise that Miss Ryan had made a choice to take advice off someone without a legal qualification. While taking nothing away from how troubling it was that someone would provide such a service for value, it was clear that Miss Ryan chose not to comply with contractual obligations in respect of mortgage payments on foot of advice from someone whom she knew was not a qualified lawyer. Her sworn statements, her affidavit could be distilled to a range of very unfortunate choices by her, all flowing from her mistake in choosing to take that advice. There was no allegation of duress or of Miss Ryan being mistaken about the man or his company having qualifications which they lacked, the judge said. The appeal was not lodged in time because of her conscious decision to follow the advice of a non-lawyer in respect of legal proceedings and non-payment of mortgage obligations. Miss Ryan might bitterly regret that, but it was not a mistake of the kind that allowed an extension of time by the High Court. Miss Ryan, he further found, had advanced unstatable grounds of appeal, that she was deprived of the opportunity to defend the case due to misrepresentations by the man, that the property was insufficiently identified in the civil bill for possession, and the mortgage was void for uncertainty because of the wording concerning the property in that bill. It was not a defence for Miss Ryan to say she was under a lot of stress in 2017, or to argue possession would adversely affect her sister with significant care needs. In the 6 years leading up to the grant of possession, the Ryans never suggested the mortgage was invalid. So the judge has held that she's not entitled to an extension of time, and she cannot appeal the home possession order which Start Mortgages have obtained. This is another of these cases where a person has taken advice from an unqualified, non-legally qualified person, a so-called, some people have described them as pseudo-lawyers, pandering and dispensing pseudo-legal advice and pretending and misrepresenting that they can actually do deals with banks, etc., etc. In this particular case, in any case, the person made misrepresentations, was paid 14,000 euros according to Miss Ryan, and the woman has now had a possession order made against her in favour of Start Mortgages. So that is the unfortunate case in the High Court, reported there in the Irish Times this week. And as I say, it's another one of these cases where a person has made the mistake of placing reliance on misrepresentations made to them by persons purporting to be able to help or give legal advice, etc., when in most cases all they're doing is driving up the legal costs and making things worse. Hope you find this video useful. If you do, I'd appreciate if you gave it the thumbs up down below. Thanks a lot.